from supplementary list for hearing item 16, second appeal 131 of 2018.
मिस्टर सहाय वाला पैकेज आप हैं इसमें? नहीं, उनका मिस्टर सहाय वाला वही है। हाँ, ये वाला
Before the Learned Senior Council starts, only last point here. Section 105 of CPC. What would be the effect of the order of remand if it is not challenged? That has been provided. So the consequence would be that the party cannot subsequently challenge. Here, they challenged. It was challenged, and the appellate order was not altered by the appellate. So that remains final till the whatever issues those were framed and those were decided by the trial court and affirmed by the appellate court, those were final.
It is 105.
105. 104 deals with miscellaneous appeals. is related to orders against from which appeal lies, and it has to be read with order 43 rule 1, where miscellaneous appeal is against the orders passed of orders of remand also. That has been provided in order 43 rule 1. Now
I won't get it. What you want to say?
yes, your lordship.
Section 105 you are placing.
Yes. Here your lordship may see subclause 2. Notwithstanding anything contained in subsection 1 where any party agreed by an order of remand from which an appeal lies does not appeal therefrom, he shall thereafter be precluded from disputing it further. So here your lordship, they had this order of remand by the appellate court. It was appellable in terms of order 43 rule 1, and despite that they preferred an appeal, but the appellate court did not alter that. So therefore, till the issues, whatever those were decided by the appellate court, those attained finality. That is my submission.
The Learned Counsel for the appellant has submitted that, has referred to section 105 of CPC and has submitted that under subsection 2 thereof, it has been provided that where any party agreed by an order of remand from which an appeal lies does not appeal therefrom, he shall thereafter be precluded from disputing its correctness. He has submitted that the order of remand was appealable under order 43 rule 1, which remedy the respondent had availed, and ultimately the miscellaneous appeal was disposed of without disturbing any finding in the first appellate judgment, and therefore findings which concluded at the first appellate stage, even if there was a remand on account of only 2 issues, attained finality.
Yes, issues, finding on issues, those were absolutely satisfied.
अब आप बीच में बिल्कुल डिस्टर्ब नहीं करेंगे, लेकिन आगे ठीक है?
हाँ,
बीच में कुछ नहीं। हाँ सर बोलिए।
May I address your lordship? May I please your lordship? So, first of all, my lord, the last submission of my learned friend referring to section 105 of the CPC, it refers to other orders, and it says that save and otherwise expressly provided, no appeal shall lie from any order made by a court in exercise of its original or appellate jurisdiction, but where a decree is appealed from, any error, defect, or irregularity in any order affecting the decision of the case may be set forth as a ground or of objection in the memorandum of appeal. So, my lord, it is one part. Other parties, notwithstanding anything contained in subsection 1, where any party aggrieved by an order of remand from which an appeal lies does not appeal therefrom, he shall thereafter be precluded from disputing its correctness. Now, my lord, the order of remand made by the learned first appellate court was taken up by the learned, was initially challenged by the defendant, respondent before this honorable court in miscellaneous appeal number 508 of 2014. The, the two issues framed by the learned first appellate court was considered in the miscellaneous appeal before this honorable court, and their lordship were of the opinion that the trial court will not travel anything beyond these two issues. In gist, that is the order of the this honorable court in miscellaneous appeal 508 of 2014. Now, Lord, the learned trial court travelled beyond, and therefore, when the remand, when upon
Kindly demonstrate how the learned court travelled beyond this, beyond the order of remand.
well, that is embedded in the appellate court judgment itself.
You read it from the trial court.
My lord,
You read it from the trial court judgment and say which portion of the finding of the learned trial court is
Well.
travelling beyond.
my lord. That order is dated 6th of April 2017. Order on remand, my lord.
Yes. You just come to that relevant portion which according to you was beyond.
My lord, in page 2, my lord, where the judgment is written,
So that this is all background. You just come to the finding of issue number 1.
I just want to place the issues, my lord.
We have read it, sir. We know we are aware of the issues.
My lord. I just for repetition's sake, my lord, what are the properties of the Chhattojha which is required to be partitioned between the plaintiff, defendant first party and second party? And number 2, whether all the heirs of Chhattojha has been made party in the present suit. Now, my lord, issues, these two issues have started at para 4, page 3, learned counsel on behalf of the defendant servant will mainly stress that the order of the first appellate court, now this court, has to appraise the evidence of on judicial record. These two issues covers the case of the parties in court. Learned counsel on behalf of the defendant 7 to 12 submit that defendant number 1 to 6 and plaintiff never came into possession over the suit property and it remained with the defendant 7 to 12. So it is not a case of partition, rather it is a case of declaration of title.
सर आप सबमिशन मत पढ़िए, कल फुल टेक्स्ट हम लोग पढ़ें. आप हमको वो फाइंडिंग दिखाइए लर्निंग अपॉन रिमांड which according to you was beyond the order of remand.
For that I will have to Para 6, my lord, in my view, all the aforesaid arguments is nothing but a futile exercise made by the parties because of the issues that whether Jagta Devi is successor of Chattu Jha or not has already been decided by trial court in issue number 4 as well as by first appellate court. It is concurrent finding of the trial court and first appellate court. Both the court have decided that Chattu Jha had 3 daughters, Jamuna Devi, Harkat Devi and Jagta Devi. So as at this stage when the case is remanded back to decide aforesaid 2 issues only, this court had no jurisdiction to re-agitate or re-appraise the issue aforesaid. It has already been
ये
decided.
ऑब्जर्वेशन तो सही है,
My lord,
ये ऑब्जर्वेशन तो सही है.
my lord, in fact, the case of the defendant has not been looked into.
सर एक सेकेंड, ये जो ऑब्जर्वेशन है
हाँ.
that issue number 4 पर there is already a concurrent finding of both the court and the court on remand is not supposed to travel beyond whatever has been asked for. This observation of the learned trial court is correct.
No, my lord.
Why?
Where is the concurrence? The trial court decided the plaintiff came in appeal and we are in appeal. Concurrence come.
नहीं नहीं, अभी तो आप
It
बोल
has
रहे
not
हैं,
salary
just a
fine.
moment. You have said that the remand order could not travel beyond the points on which it was remanded. Correct?
My lord.
You just tell us where is the point regarding issue number 4 in the order of remand.
नहीं है.
नहीं है ना?
नहीं.
Issue number 4 had become final.
नहीं. In fact, my lord, issue number 4, the appellate court would decide. If the trial court has decided something, and appellate court is in session of the matter,
But at least that was not a point of remand.
हाँ नहीं था.
Okay.
नहीं. वो तो हम मान रहे.
That was not a point of
नहीं.
remand. Therefore, there was no scope for the trial court to go into that issue.
Never. Rather, I would humbly submit at the relevant time I will place that the definite case of the defendant in the written statement of defendant 7 to 12 was that Chattu Jha had 3 daughters, namely, name is important, Bachi Devi, Jagta Devi and Harkat. From where Jamuna Devi has come is also given in the written statement. It is discussed in the trial court judgment. And on that basis, the plaintiff is non-suited. And therefore the appellate court has said, I'm sorry, my lord was writing.
नहीं हम
The learned,
सुनना, देखना
ठीक,
और लिखना, हम आप एकदम सीमलेसली बहस करिए, आपकी हर बात हम नोट करें.
हाँ, ठीक
अभी
है.
ऑर्डर लिखाएंगे तो आपका कोई बात छूटने वाला नहीं.
नहीं. My lord, in the written statement, I reiterate, in the written statement, the defendants 7 to 12 said that Chattu Jha had,
I have noted it, sir. Don't repeat
हाँ.
any sentence unless I ask you to repeat.
my lord,
Not required.
my lord. So, there is no reference in the written statement that Jamuna Devi was daughter of Chattu Jha. She was daughter of Sobhapuri. If I am permitted to read the trial court judgment and even the
Sir,
appellate court.
first finish this remand order. इस remand order पे हम दोबारा नहीं आएंगे.
Hi.
जो भी आप ऑर्डर खोलिए, आप उसका हर एंगल, हर चीज आप उसका कंप्लीट करिए.
My lord. So at this stage, when the case is remanded back to decide aforesaid 2 issues only, this court has no jurisdiction to re-agitate or reappraise the issue aforesaid. It has already been decided that Chattu Jha had 3 daughters and the plaintiff and all defendants are successors of Jamuna Devi, Jagta, both daughters of Chattu Jha, as Harkat Devi died issueless. On the point of succession or further, is there any other heir of Chattu Jha there is no evidence adduced on behalf of both the parties after framing these two issues aforesaid. So again and again recitation of evidence already discussed by trial court and first appellate court will be futile. On the basis of evidence available on judicial record, I find and hold that all the heirs of Chattu Jha has been made party in the present suit. So far the issue that what of the properties of late Chattu Jha which is required to be partitioned between the plaintiff, defendant, first party and second party is property described in schedule of the plaintiff. On this issue, both the parties have again not adduced any evidence after framing of these two issues aforesaid, so that properties remain same, that is given in schedule A by 1 and A by 2 of the plan. The property aforesaid will be divided into half and half between Jamuna Devi and Jakta Devi, and then from half share of Jamuna Devi it will be divided again half and half between Sardar Jha and Shankar Jha. As Sardar Jha had no issue, so the share of Sardar Jha will devolve to the nearest against Shankar Jha as rule of survivorship, and again it will be partition in between Jitendra Jha, Rajendra Jha and Mahendra Jha equally, and out of the share of Mahendra Jha it will be partitioned equally between his 4 children. The rest half share of Jakta Devi will be divided first 1/3 equal to Nand Kishore Chaudhary, Rameshwar Chaudhary and Gena Devi. As Nand Kishore Chaudhary had no issue, his share will be divided upon the nearest against Rameshwar Chaudhary. Share of Rameshwar Chaudhary will be divided equally between defendants 7 to 9, and share of Gena Devi will be divided equally between defendants 10 to 12. As I earlier discussed, this court has no jurisdiction, and admittedly law does not permit this court to travel beyond the order of the first appellate court. So, on the argument made by the parties, no further finding can be given apart from the two issues aforesaid. Now, thereafter the appellate court has given its judgment, which is under challenge before your lordship. The impugned judgment is dated 25th January 2018 at page 27, I think.
What are the issues framed by the learned first appellate court?
Miller, point for determination was not framed, and apparently it violates order 41 rule 31 CPC. But what has happened in this case, the
So you are
learned,
supporting the appellant on this one?
no, Miller, my humble submission is that the first appellate court has dealt with all the pleadings, all the evidences, both oral and documentary, given in the case, and therefore, in my humble submission, non-framing of the point for determination will not defeat the ends of justice.
He will not decide, he will not dispute this.
My
He will not dispute this proposition.
lord. There is
His only contention is one line, and I will not repeat this line. His only contention is in the first round, whatever stood final could not have been reopened by the first appellate. एक सेंटेंस का यही सबमिशन है इनका, बैकग्राउंड उन्होंने जितना भी बताया, इसके अलावा कोई सबमिशन नहीं. This is the only submission where the entire case has to be decided on the basis of this submission.
So let me understand it, my lord, that whether there are two judgments by the first appellate court.
I do not know. वो आप समझिए.
My humble submission is this is the only judgment of the learned first appellate court upon which a decree would be made. Earlier, the learned first appellate court heard the case, remanded the matter. So the first appeal remained pending before the court. And after the exercise of remand, it came to the first appellate court, and the first appellate court gave judgment on 25th of January 2018. So this is the only judgment.
So the earlier judgment is no judgment in the eyes of law.
Winner, can my
Earlier
friend?
judgment when there is a limited remand. Suppose
Yes.
there are 10 issues in a case. The court says that yes, 10 issues are there, all the issues have been decided, but the point of limitation has not been decided. Let's assume such a situation. The court says it's a mixed question of fact and law, so on this point I want to remand it. And ultimately, if the trial court finds that so far as the point of limitation is concerned, it was barred by limitation. Then the appellate court will decide only on the point of limitation, because rest of the issues the court says that there is no illegality.
In my humble submission, my lord,
Then and if ultimately the trial court finds that there is suppose the trial court finds that no, it was not barred by limitation, then any person aggrieved by that finding, right, will have a right to challenge that finding of the learned trial court only to the extent that it was not barred by limitation or barred by limitation, right?
so far challenging the order of remand by the trial court, a miscellaneous appeal could be filed. Parties have
That
chosen not to
done.
file.
No, this you have already done.
In the first,
It was challenged.
when the
MA number 508 of
508 of 2014, I have done that, I
Yes, you have
remember.
done it.
My lord, that was against the order remanding the case to trial court after framing two issues. But upon deciding those two issues, I have not challenged decision on those two issues because I knew I have a remedy before the learned first appellate court to deal with the case. And in my humble submission, the learned appellate court, first appellate court, has passed only one judgment deciding the merits of the case, and that is by the impugned order.
Okay.
And therefore, my humble submission, in my humble submission, the judgment of what I have understood, firstly, I must submit that according to the plaintiff appellant's submission, the judgment rendered by the first appellate court on 25th of January 2018 is a second judgment given by the first appellate court, which is not permissible. This is the query which, if I have understood it, in my humble submission, the judgment which was challenged in MA 508 was not the judgment on merits of the case, on the facts of the case, and the judgment was only with regard to referring the case of the parties and then framing two issues and remanding it to the trial court so that the trial court may decide these two issues. Then I will look into the other issues involved in that case. So the issue number 4, was required to be dealt with by the lower appellate court. Otherwise, it would have become illegal because the issue number 4 would not be dealt if had not been dealt by the appellate court in the impugned judgment. Then it was the judgment would have become nullity. If I am permitted to read the first judgment of the first appellate court, Milord, that is only with regard to remand. And therefore the learned court below was duty bound to deal with the facts and the evidences of the parties, both oral and documental. And it's not a very long judgment. If I am permitted to read, even by giving the important paragraphs in it. The present, may I read my?
आप एकदम हमसे कुछ मत पूछिए, हमें हर चीज आपका सुन रहे हैं।
The present appeal has been preferred by the above named appellant against the impugned judgment and decree dated 12/11/2009 and
सर यू कैन रीड इट वेरी फास्ट, आप एकदम तेजी से पढ़ सकते हैं क्योंकि हम तो पढ़ रहे हैं।
26/11/2009 respectively passed by Sri Anil Kumar Singh entitled Partition Suit number 274 of 1997, whereby the suit of the plaintiff was dismissed. The brief fact of the case of the plaintiff as per plaint is that the parties are Hindus governed by Mitaksara School of Hindu law. Then I skip a little bit. Late Chattu had no son but 2 daughters. Jamuna Devi and Harka Devi, out of which Harka Devi died issueless. Shankar Jha, father of the plaintiff, had given power of attorney to Rameshwar Chaudhary and Satyanarayan Shah to supervise his work, and accordingly, Rameshwar Chaudhary was addressed as Chacha and Muh Bola Chacha. Lord, in my humble submission, in this case, at so many places, Muh Bola Nati, Muh Bola Chacha, these things are, those people cannot claim partition. And it is said that the person Shankar Jha was a Muh Bola Nati. He was not Nati, Muh Bola Nati. I will come to that one. Shankar Jha, the father of the plaintiff, had given power of attorney to Rameshwar Chaudhary and Satyanarayan Shah to supervise his work, and accordingly Rameshwar Chaudhary was addressed as Chacha, that is Muh Bola Chacha. Under wrong impression and hearsay version of elders, Rayat, of Mauja and strangers, Rameshwar Chaudhary was called Muh Bola Nati of Chattu Jha. After the death of Harka Devi, defendant second party and third party, who were heirs of Kirti Jha, are neither related with Chattu Jha nor they have any concern with genealogy of Chattu Jha. So, my lord, either the defendants second set, defendants 7 to 12 are the real persons to inherit property of Chattu Jha, or they are not. It cannot be in piecemeal, half and half or 1/4, nothing. Either yes or no. After death of Harka Devi, the defendant second party and third party, who are heirs of Kirti Jha, are neither related with Chattu Jha nor they have any concern with genealogy of Chattu Jha. To explain the relationship of defendant second party and third party, their genealogy table is given in the plain. Chattu Jha, son of late Sobhapuri, was a man of influence, having sufficient immovable and movable property, but was extravagant. Chattu Jha was Pradhan of village Barasati Ghat. नाम गलत लिखा हुआ है. P.S. Mohanpur. He had no son but 3 daughters. All are shown in genealogical table mentioned in the play. Out of two daughters of Chatuja, one daughter Hakha Devi died issueless during the lifetime of Chatuja. Due to failure to pay the rent as Pradhan, Chatuja was dismissed in Pradhani eviction proceeding case number so and so. Shankar Jha was appointed in place of Chatu Jha, and the said appointment was approved by the then Deputy Commissioner. Milord, may I pause for a moment that if the Nana is dismissed from the post of Pradhan, how Nati would be appointed as Pradhan? His entire family will be precluded from being appointed. A third family would be given a chance. If in eviction suit one fails, his relations cannot claim Pradhani. The land of Mauja Barasati Ghat remained placed as security of village for village rent. During his lifetime, Chotu Jha had made transfer of some land in favor of Nati Shankar Jha, which was subsequently recorded in the name of Shankar Jha, and similarly some lands were recorded in the name of Jogmaya. Pause for a moment. The exhibit 9 by A, my lord, is a transfer list, which today is like mutation case. Now exhibit 9A is an order of inquiry by a magistrate, assistant settlement officer. He says name of Shankar Jha may be recorded in Jamabandi. Obviously, Jamabandi is today a mutation case. So, my lord, number one, that sale deed has not been annexed. How a mutation case would become a matter of consideration without the sale deed in a title suit? And how a mutation officer, so assistant settlement officer, would be entitled to declare title of someone? He has no right to declare title. And the sale made by Chotu Jha in favor of Shankar Jha was the matter in consideration in exhibit 9 by A. It was not by way of inheritance. Chotu Jha sold some land to Shankar Jha, and that was recorded in the transfer list case. The land of Mauja Barasati Ghat remained placed as security of village rent. During his lifetime, Chotu Jha had made transfer of some lands in favor of his Nati, Shankar Jha. इसी का हुआ है exhibit 9 by A, म्यूटेशन. अब म्यूटेशन का ना केस नंबर है ना ऑर्डर शीट है. Let me know how mutation is done. Mutation is an old matter. It is now made a part of Act of 1973. And similarly, some land were recorded in Jogmaya Devi, wife of Sardar Jha, and other Nati of Chotu Jha. Similarly, the land which were transferred by the said Chotu Jha in favor of Kishore Chaudhary and Rameshwar Chaudhary were recorded respectively in their names. The land which were recorded in the name of Shankar Jha and name of Jogmaya Devi are in peaceful possession, enjoyment of son and grandsons of the late Shankar Jha in terms of amicable settlement. Of course, he has purchased. In exhibit 911, the magistrate said record his name in the Jamaban. That is in the mutation matter. After death of Shankar Jha in the year 1961, his son Mahendra Jha was appointed Pradhan, after whose death his son Manish Jha was appointed Pradhan with his uncle Jitendra Jha as Sarbar Guardian, and he continues as such. Chotu Jha died after some time in 1934, leaving behind only one daughter, Jamuna Devi, and daughter's son. Plaintiff and defendant first party are their descendants. Properties in the suits recorded in the name of Chotu Jha are described in Schedule A by 1 and A by 2, which is referred as suit property. The parties possessed the said properties according to choice and convenience without actual partition by means and bound according to legal share, and due to this some ugly quarrel and trouble occurred, as a result of which plaintiff suffered inconvenience and loss due to his simplicity. Hence, time has arisen for the suit for getting matter settled once for all and to get separate party allotment of land according to their legal share. The defendant, second party and third party are made pro forma defendant so that the suit may be decided in their presence. Now, may I submit that Order 1, Rule 10, Sub-Rule 2, inclusion of improper parties will defeat the suit. No one is given liberty to include anybody or to remove
We do
anybody.
not argue anything which does not form a part of the substantial question of law.
But I am placing
Anything which is not a part of the substantial question of law is not to be decided.
mine.
So please do not
So,
make
sir,
any arguments on
what
that.
I have understood, this honorable court has on 25th of March 2025 has framed the substantial questions of law. I will place that.
Which are for you are talking about non-joinder, misjoinder of necessary parties. It will be covered under which substantial question of law? You just tell me that. Under which substantial question of law this argument of yours will be covered?
Let me place it. These pro forma defendants have no share nor interest in the suit property. Plaintiff has 1/4 share in the suit property. The plaintiff prays for following relief, such and such. On notice, the defendant appeared and filed their respective written statement on 24/4/94. The defendant first party appeared, filed their common written statement wherein they have stated they have supported case of the plaintiff. Before the service settlement, widow Jogmaya Devi died before passing Hindu Succession Act 1956. In such case, hence Jogmaya Devi has no right, title or interest in the suit properties. Rameshwar Chaudhary, father of defendant second party and defendant third party, had tried to engage upon the lands of Shankar Jha, which are in possession of defendant's first party, including plaintiff. Although there was no partition by means or bounds between the two branches of the heirs of Chotu Jha, it may further be noted here that Rameshwar Chaudhary was joint power of attorney holder of Shankar Jha, Pradhan, along with one Surya Narayan Saha, which was executed in their favor in the year 1942. Rameshwar Chaudhary made the said power of attorney as his capital right from Lakshmipur estate and all courts and offices of his personal gain. He paid rent on behalf of Shankar Jha but managed to get his name entered in the Marfati column of the receipts. If the rent is deposited by someone, he will not become a shareholder of the owner. Marfati means one who deposit the rent. He may be a karta, may be a kamiya, may be a employee. In the Marfati column, he retained all the valuable documents, being custodian of all the documents, but he should not be allowed to take advantage of the same. After the death of Shankar Jha in 1961, in order to grab the entire land of Shankar Jha, that he, along with his sister Gena Devi, tried to enter their name in register too by concocting a bogus story and got success initially before the circle officer. But later on, his fraudulent game was exposed by revenue officer through inquiry and as such the name of defendant Rajnandan Jha, Mahanta Jha, and husband of defendant number 2 and father of the other defendant's first party, including the plaintiff in revenue record with Rameshwar Chaudhary and Gina Devi in all 3 villages, Barasati Ghat, Chandayan and Chakrama, as legal heirs and recorded tenants of Chhattu Jha, while order dated 15/1/1965 passed in revenue miss case number 13 of 1964-65. This is what I was submitting below. Exhibit 9A do not have any reference to mutation case. Revenue miscellaneous case number so and so. इस तरह का उसमें नहीं है. Being frustrated on this front, Rameshwar Chaudhary used criminal force resulting into proceeding under 144, which was later on converted into 145, being criminal case number such and such. The London Magistrates B.N. Panda erroneously declared position of the first party, but the said finding was passed on the fact of the law, as the land where Rayati non-transferable holding has the question of ouster and dispossession are meaningless. The declaration of possession in a criminal proceeding cannot create right, title and interest in the defendant's second party or third party with regard to the land in question. The finding of the land magistrate as to relationship of Mahendra Jha with Chhattu Jha was passed on imagination of Rameshwar Chaudhary. The entire finding of the London magistrate in aforesaid case was passed on affidavit, which was then prevalent, but affidavits are not evidences. These defendants have been paying rent. They have got topography changes in the land in question. These defendants have got no disagreement with the plaintiff. They are the supporting defendants, 1 to 6. Regarding the stand against the defendant, and accordingly the suit for the partition as a legitimate share should be decreed and separate party carving out the legitimate share of the defendant may be allotted in their favor. This case of the defendant first party, 1 to 6. In view of the amendment in plain dated 21/1/2003, the defendant 1 to 6 filed additional written statement. They are going along with the plaintiff file. On 28/8/2009, after 6 years, wherein they have submitted that amendment brought in the plaint by the plaintiff is correct. The defendant have fully supported the case of a plaintiff of amendment and stated that in fact Chhattu Jha had 2 daughters, namely Jamuna Devi and Harka Devi, out of which Harka Devi died issueless. The plaintiff and defendant 1 to 6 are legal heirs and successors of Chhattu Jha, being grandson and grandsons and other legal heirs of his only daughter Jamuna Devi. Rameshwar Chaudhary and Kishore Chaudhary had no blood relation with Chhattu Jha, nor related as Nati, rather being Sevak of Chhattu Jha. Some lands were given to him as same was recorded in their name. As the descendants of Jagta Devi were not related with Chhattu Jha, hence they have no interest in the suit property. I will not have this that if they are not related to Chhattu Jha, why they were made parties to the suit? There was no purpose to make them party in a partition suit. As some of the previous litigations, these defendants were party, hence they were made pro forma defendants. So if there was a case of 145, they will be made party in a partition suit. These defendants were party, hence they were made pro forma defendants in the suit so that the suit may be decided in their presence. The plaintiff as well as the defendant 1 to 6 each have 1/4 share and interest in the suit property. Now we have the case of the contesting defendant, the starts of para 5. The defendant second party and third party, which include defendants 7 to 12, filed their written statement on 12/1993, wherein they have stated that these defendants did not admit relationship claimed by the plaintiff. The genealogical table and the order of Jagta Devi's death are false and denied. Jagta Devi died in 1957 and not in 1953. Jamuna Devi was not the daughter of Chhattu Jha. These are the factual aspects. Was in fact the daughter of Baijanath Puri, who was orphan boy picked up by Shobha Puri, took pity on him, brought him and named him as Baijanath Puri and entrusted him to take care of Chhattu Jha. If they are interested in entrusted him to take care of Chhattu Jha. Chhattu Jha addicted to intoxicant and was in loose morals, indulging in such prostitution and concubine, which is evident from the fact of his reckless and illegal transfer of lands in favor of his concubine, which was recorded in Jamabandi number 19 of Chennai in the name of his illegal sons Hari Rao and Narayan Rao. Thus, Shankar Jha and Sardar Jha were never Nati of Chhattu Jha. And Shankar Jha maneuvered illegal entries of land in their favor. The genealogical table is provided in this written statement. Bachi Devi died in childhood. Harka Devi died issueless during the lifetime of her father, who died in 1947, leaving behind his only daughter Jagta Devi. And as sole heir, and his properties, including the suit properties, devolved upon her as the sole heir, and was continued to process the same as absolute owner of the same till she died in 1957. And she succeeded by her son Rameshwar Chaudhary and daughter Gena Devi, whose branches these defendants form. That is one defendant 7 to 12. Harka Devi and Bachi Devi both predeceased Chhattu Jha, which was survived by Jagta Devi alone. Shankar Jha was never a Nati of Jamuna Devi and Jamuna Devi was not a daughter of Chhattu Jha. Transfer of land in favor of Sardar Shankar Jha, Yog Maya Devi and others were the result of undue influence, fraud, etc., all void and illegal. The allegations about the family settlement, partition, etc., have been deliberately kept vague by the plaintiff with ulterior motive. These defendants are admittedly in possession of the land already transferred in favor of Nandkishore Chaudhary and Rameshwar Chaudhary. Chhattu Jha died in or about 1947 and left behind his only daughter Jagta Devi, who succeeded him. Jamuna Devi was not the daughter of Chhattu Jha. The genealogical table given by the plaintiff is false and concocted. The plaintiff and the defendant's first party are in collusion, and the plaintiff has been set up to file this false and untenable suit. It is important to note that criminal case 246 of 1965 under section 145 CRPC was fought between these defendants and the plaintiff, in which the defendants were the first party and plaintiff was second party. By order dated 7/7/1967, the learned executive magistrate so declared the possession of first party and forbade the second party from disturbing the same. The defeated second party filed revision in criminal division number 76 of 1967, which was also dismissed in 1968. Thereafter, the plaintiff and his uncle or defendants, first party, never raised their head and they were not allowed to put their legs on the suit property. So from 1965 they were out by the orders of the criminal court, a magisterial court. The order passed under 145 become final, and the same was never set aside nor was challenged. The statement about possession by the parties according to choice of the and convenience with the occasional word was not true, and the same is unbelievable. The various transactions including Banda by Rameshwar Chaudhary will falsify the plaintiff's claim. These defendants have been paying rent, but the rent of Satigha is not being accepted by the Pradhan of defendant's family. The plaintiff has no right, title or possession, and not entitled to any share at all in the suit properties. The defendant third party are in possession as original owners, being successors of Gena Devi, who was a class 1 heir and succeeded Jagta Devi. There is no dispute among the defendants, second party and third party. Rameshwar Chaudhary and Gena Devi both were the winners of 145 CRPC proceeding. Chattu Jha died long before enforcement of Hindu Succession Act 1956 and was succeeded by his only daughter Jagta Devi, who died as absolute owner in 1957. Thus, the plaintiff has no case at all, and the suit is bound to be dismissed with caution. This is the case of the defendant of 7 to 12 in the written statement. On 26/9/2004, additional written statement was filed on behalf of defendant 7 to 12, defendant second set and third party, where they submitted that proceeding under section 145 being criminal case number 164 of 1966, the parties being Rameshwar Chaudhary and others versus Mahendra Jha and others. This Mahendra Jha is the own brother of plaintiff Jitendra Jha. As such, the above order in the criminal case is equally applicable and binding on Jitendra Jha, this is the plaintiff, and other brothers of Mahendra Jha. Even from the point of view of these defendants, remain in adverse position for more than 12 years and possessed till now. It was only in the year 1993 that this sword was preferred, which is barred by law of limitation. It was after 12 years. On the basis of pleadings on both the parties, the following issues were framed on 8/9/2009, which are as follows. Now, I skip the writing on the issues. Issue number 4 is given whether Chattu Jha has only two daughters, namely Jamuna Devi and Harka Devi, or had one another daughter, namely Jagta Devi. Now, para 8, my lord, during course of evidence, both the parties are led oral as well as documentary evidences on the basis of argument of both the parties, and after perusal of the evidences on record, that the trial court dismissed the suit on contest with cost. Being agreed by and dissatisfied with the impugned order and decree of the trial court, plaintiff appellant filed the present civil appeal being before this court on amongst other several grounds. So, my lord, the final judgment in the appellate court is the impugned judgment before my lords. The learned counsel Sri Maheshwar Chaudhary, appearing on behalf of the plaintiff appellant, submitted that impugned judgment and decree passed in title suit number 274 of 1997, Jitendra Jha versus Rajendra Jha, and others by the learned court below is illegal, erroneous, and fit to be set aside. The learned court below has heard before both on ground of law and fact. The learned court below has wrongly and illegally decreed the suit in favor of the defendant respondent. The learned court below has failed to appreciate the provisions of law and the facts involved in the suit, due to which the plaintiff appellant suffered serious miscarriage of justice on the basis of grounds mentioned above. Learned counsel for the plaintiff placed that the impugned judgment, dated sanction passed by so and so, may be set aside and this appeal may be allowed. The Land Council for Mr. K.C. Tiwari, appearing on behalf of the defendants, submitted that the trial court has evaluated the evidences correctly and legally and has rightfully reached to the conclusion and passed the impugned order, judgment and decree in favor of the defendants. He prays that the impugned judgment and decree passed by the court below may be upheld and the appeal may be dismissed. The finding is started from para 12 minor, heard both the parties and perused the material available on record. It appears that the present title appeal has been filed against impugned judgment and decree dated 12/11/2009 and 26/11/2009 respectively, passed by Sri Anil Kumar Singh, subordinated 4th Governor, entitled parties of suit number 274 of 1997. Chief Officer Rajan Jha and others, it is pertinent to mention here that after passing of the aforesaid judgment and decree, the present title appeal was preferred by the judgment dated 20, which was numbered as title appeal number 27 of 2009. This appeal was heard by an additional district judge from FTC to Devghar. After hearing both the sides and perusal of evidence on record, the court of FTC to Devghar passed its judgment on 21/2/2011, where he remanded the suit to the trial court of subordinate judge for Devghar. The court of FTC to frame two issues and directed the trial court to decide these issues after giving an opportunity to the parties to adduce evidence and to decide the partition. Against the aforesaid order of the court of FTC to Devghar, the aggrieved party moved before the Honorable High Court of Jharkhand Ranchi by filing a writ petition which was numbered as WPC number 3058 of 2011 against the order of remand passed by the court of FTC to Devghar. By its order dated 12/11/2014, the Honorable High Court of Jharkhand Ranchi dismissed the petition stating that same is not maintainable. Thereafter, a miscellaneous appeal being MA 508 of 2014 was filed by the defendant before the Honorable Court against the same order of the court of FTC to Devghar. After hearing the parties, the Honorable Court by its order dated 2/2/2017 decided that the trial court is directed to decide the issues as formulated by the first appellate court and return the finding within 2 months to the appellate court, which shall decide the appeal within 4 months thereafter. So, this is direction of the Honorable High Court also. Get the issue finalized by the trial court and then decide it within 4 months thereafter. And upon which this judgment has been passed, which is impugned before this Honorable Court. The Honorable Court further observed that the observations and directions by the lower appellate court to the trial court for deciding the suit for partition was not warranted. Accordingly, the trial court shall exercise its own discretion in deciding the issues in accordance with law without being influenced by any observations and directions of the first appellate court for deciding the suit for partition. In the light of the above order, the High Court of the Jharkhand Ranchi and Trial Court of Subject 7 Devghar by its judgment dated 6/4/2017 decided the suit. Further perusal of the judgment dated 6/4/2017 passed by the land subject 7 Devghar, it appears that apart from deciding the two issues formulated by the FTC to Devghar, the trial court also decided the suit for partition that was in excess of the remand order and also decided the share of the parties. From perusal of the order of the Honorable High Court passed on 2/2/2017 in miscellaneous appeal number 508 of 2017, it transpires that there was a specific direction to the trial court for deciding two issues only and sent the same to the first appellate court and thereafter it was directed to decide. Appellate court was directed to decide it within 4 months thereafter. The Honorable Court also observed that the trial court was not required to be influenced by any observations and directions of the first appellate court for deciding the suit for partition. In this matter, the Honorable Court had observed that the direction by the lower appellate court to the trial court for deciding the suit for partition was not warranted. Thus, there was a specific direction of the Honorable Court to trial court to only decide the two issues and return its finding to the first appellate court. But trial court of the subordinate judge 7 were exceeded in its jurisdiction and also decided the suit. That is, without deciding the partition and etc. As such, the finding of the court of the subject 7 Devgar and with regard to two issues formulated by FTC 2 Devgar is accepted for consideration while deciding the present title appeal. But so far as the other part of the judgment dated 6/4/2017 passed by the subordinate judge 7 Devgar in title suit number 274 of 1997 is discarded as void ab initio and the same was passed without jurisdiction. Then below para 13, as a result of cumulative effect of several proceedings and other order passed therein, particularly the last order passed by the Honorable Court in MA 508 of 2014, this court heard both the parties and produced the evidences on record as well as finding of the trial court with regard to two issues which were formulated by FTC 2 Devgar. It is pertinent to mention here that plaintiff had initially filed the plaint wherein they had stated that recorded tenant Chhattu Jha had three daughters, namely Jamuna Devi, Jakta Devi and Harka Devi. Harka Devi died issueless. The plaintiff and the defendant 1 to 6 are the descendants of Jamuna Devi, whereas the defendants 7 to 12 are the descendants of Jakta Devi. In order to substantiate their contentions, they adduced several evidences to prove the facts that Chhattu Jha had three daughters, being descendants of Jamuna Devi, defendant of 1 to 6, filed a written statement supporting the case of the plaintiff that recorded tenant Chhattu Jha had three daughters, out of which one Harka Devi died issueless. These defendants also adduced evidence in support of the case of the plaintiff in the plaint. Thereafter, the contesting defendants 7 to 12, who are descendants of Jakta Devi, another daughter of recorded tenant Chhattu Jha, as per plaint, filed their written statement wherein they refuted the claim of the plaintiff and the defendant 1 to 6 by stating that Jamuna Devi was not the daughter of Chhattu Jha, rather she was daughter of another person, Baidyanath Puri, orphan boy picked up by Subha Puri, father of recorded tenant Chhattu Jha. Baidyanath Puri was brought and was entrusted in the care of Chhattu Jha. These contesting defendants further submitted that Chhattu Jha had three daughters, Bachchi Devi, Harka Devi and Jakta Devi. They examined 8 witnesses on their behalf in support of the contents of their written statement and against the claim of the plaintiff. Surprisingly, at this stage, the plaintiff amended their plaint. In their plaint, the plaintiff came up with a new fact that Chhattu Jha had, in fact, only two daughters, Jamuna Devi and Harka Devi. These practices should be looked into very seriously. After amendment of the plaint, the former defendant 1 to 6 also changed their stance to suit the plaintiff. So this supporting defendant also changed their stance in his amended plaint and filed a supplementary statement stating therein that the same in fact was mentioned in the amended plaint. This creates serious doubt as to which type of descendants, the plaintiff and defendant 1 to 6 are that they have no knowledge whether Chatuja had 3 daughters or 2 daughters. In the original plaint, they have accepted that Jagta Devi was daughter of Chatuja, but in the amended plaint, they denied this fact and extinguished the existence of Jagta Devi as daughter of Chatuja. This also creates serious doubt about the genuineness of the contents of the claim. Besides all, the oral evidence made by several witnesses who were examined on behalf of the plaintiffs and defendants existed on record. These evidences all speak about that Jagta Devi was daughter of Chatuja. And 14. So far, the documentary evidence are concerned, the very beginning, the stand of the defendant 7 was that Jamuna Devi was not the daughter of Chatuja. Neither Jamuna Devi nor their descendants were ever title holder of the suit properties or possessed the suit properties after the death of Chatuja. In order to prove their possession, the plaintiff had filed a case under 145 CRPC in which the plaintiff side was the first party and the contesting defendant were the second party. In this proceeding, the plaintiff was declared in favor of possession was declared in favor of the second party, defendant 7 to 12. Against that order, the plaintiff side preferred division, but the plaintiff lost the same. Thus, the order of landed magistrate declaring possession of defendant 7 to 12 became final. In the ongoing survey records of right prepared after the speak stage, inquiry stage, after rejection of the objections raised by the plaintiff and defendant's first party, has been prepared in favor of defendant 7 to 12. Though these documents are not final, but prima facie, they prove the existence of possession of the defendant 1 to 7 over the suit properties. The defendants have filed the copy of the order and relevant documents related to proceeding under 145 CRPC and the order of the revisional code which was preferred thereon, and also the records of the right for the 3 villages for the ongoing survey processes. These documents have been properly marked and exhibited as Exhibit M, H, N, I, Q, R and T respectively. 8 exhibits. Thus, para 15, thus from the analysis of evidences, both oral as well as documentary evidence adduced by the both parties, it transpires that plaintiff had not remained firm on the stand regarding genealogy of the record of the recorded claims, which creates serious doubt about the genuineness of the claim of the plaintiff. First, the plaintiff and the pro forma defendant have accepted that Ta was daughter of Chatuja, and subsequently both of them changed their stand, which also creates serious doubt about their own existence, as to whether they are the descendants of Chatuja or not. Had they been the descendants of Chatuja, then they must have known that how many daughters Chatuja had. Even the witnesses who have been examined on their behalf have also stated that Jagta Devi was the daughter of Chatuja. In such circumstances, how they can resign from the earlier stand? On the other hand, the defendant 1 to 7 have taken a firm stand and have remained consistent all through that Jagta Devi was daughter of Chatuja and Jamuna Devi was not the daughter of Chatuja. 1 to 7 of this 7 to 12 होना चाहिए.
There is also a finding that prima facie the court found that the possession was with defendant number 1 to 7 over the suit.
वो 7 to 12 होना चाहिए.
हम लिखते हैं दोबारा इसको.
My lord, as per the recording I see, it is not by presumption.
ठीक है, anyways.
Taken
सर
by
देखिए एक चीज आपको बता दे रहे हैं.
जी.
ठीक है, आप जो ये पूरा जजमेंट पढ़े ना, आपको you know that I read the entire thing and come. You can just you see you have been reading it for around 1 hour.
My lord
Our
said that
time
you read
is-
without any break.
No,
I have read it.
it doesn't mean that. I told you that I have read everything. You can just come to the point. But you insisted that you want to read it. 1 घंटा से हम
अब तो हो गया,
आपका
तो
ये
खत्म
पूरा
हो गया।
जजमेंट पढ़ रहे हैं.
अब तो हो गया,
This
खत्म
is
हो
not
गया।
the way in which appeal is to be argued. ऐसा तो क्या है ना कि पूरा हम शुरू करें पढ़ने से तो 1
नहीं,
महीना
तो-
1 month it will take.
ये तो ऑनरेबल कोर्ट की
नहीं, मेरा कोई डिस्क्रिप्शन नहीं है. अगर आपको रोकेंगे
my
तो आप
lord says-
बोलेंगे कि आपको सुनते नहीं है. लेकिन जब
अभी हम बोले
जब आप सीनियर
कोई
एडवोकेट
नहीं
बहस
बोला।
कर रहे हैं,
आप
जब
बहुत सुनते
नहीं
हैं।
ऐसा बात नहीं है.
Contesting
इररेलेवेंट
different-
चीजें बोलेंगे तो हमको बोलना ही पड़ेगा ना. हमारा टाइम बहुत प्रेशियस है सर. Lot of public money is involved in every minute we spend in the court. So we have to be very precise. मेरा ड्यूटी है कि हम पढ़ के आए और आपका ड्यूटी है कि आप रेलेवेंट चीजें
You
खाली
realize. So otherwise I would have read this much.
I do not know. 1 घंटा से तो आप पढ़ रहे हैं.
Contesting defendants 7 to 12 have not only proved their case by adducing oral evidence but also by documentary evidence which outweighed the oral evidence of the plaintiff. On the other hand, the contesting defendant have succeeded in bringing both oral and documentary evidence in support of fact that Jamna Devi was not the daughter of Chatuja, and on the other hand, Jagta Devi is daughter of Chatuja. So this is the finding of fact on the basis of the evidences, both oral and documentary, given by the learned first appellate court. And thus the court says, I have reached to the conclusion the plaintiff has not been able to prove his stand that he is descendant of recorded telling. Though the learned court below has dismissed issue, but while deciding issue number 4, the court has dealt with it. The trial, while deciding the issue number 4, the trial court has accepted that Jamna Devi was daughter of Chatuja, whereas this court has reached to a finding that Jamna Devi was not the daughter of Chatuja. This is the finding of the court on the basis of the evidences. As such, with the aforesaid modification in the judgment of trial court, the impugned judgment and decree dated 12/11/2009 and 26/11/2009 respectively, passed by so and so, is hereby upheld. So, in my humble submission, the learned first appellate court has dealt with each and every fact and evidence of the case and has come to the conclusion that the plaintiff has failed to prove his relationship with Chatuja.
उनका submission.
Number 2, he has
Sir, we have read it. You say that every aspect of the matter has been taken by the first appellate court and findings have been recorded after considering the materials and there is no scope for interference.
Madam,
No scope for interference in the first
no
appellate.
scope for interference.
We take care of it.
As I was submitting my lord, sir, observe that order 41/31
Sir,
they
repeat
will
मत
not-
करिए. एक sentence भी repeat मत.
and exhibit 9/1 on which my learned friend
Sir, that also you have already submitted.
yes. And the questions of law Miller in the my lord's order, it is summarized in one order itself.
So question of law-
2025.
Question of law दोबारा पढ़ने की जरूरत
नहीं।
नहीं है.
बस वही है.
The learned
But
counsel
such
for the
persons-
respondents.
Such persons will not, should not be given advantage of their planned device.
ऐसा कोई finding नहीं है.
Plaintiff, my lord, he
Sir,
has
जो
changed
चीज-
the entire case by making a
Sir, we are on
amendment to the plaintiff.
substantial question
बोले
of
जी
law.
जी दूसरा ले आए.
कंडक्ट ऑफ पार्टी पर
Yes.
कोई सब्सटेंशियल क्वेश्चन ऑफ लॉ नहीं बना
नहीं,
है.
नहीं.
इसीलिए उस कंडक्ट पर आप मत जाइए.
ठीक.
दैट विल नॉट प्रेजुडिस माय माइंड इन एनी मैटर. अगर कंडक्ट पर बनता सब्सटेंशियल क्वेश्चन ऑफ लॉ आई वुड हैव एप्रिशिएटेड.
But-
अदरवाइज देयर इज नो स्कोप.
तो इन्हीं को बनवाना था. I am nowhere there.
आई डू नॉट नो.
Obliged. Obliged, my lord.
The learned, एक second, that submission record. The learned counsel for the respondent has placed almost full text of the order passed by the learned trial court upon remand. The order passed in MA number 508 of 2014, whereby the order of remand was challenged, and also the subsequent order passed by the learned appellate court, which is under challenge in the present proceedings. The learned counsel has submitted that there cannot be two judgments, one prior to remand and other after the remand, and what survives is only one judgment of the learned first appellate court, that is the impugned judgment before this court. He has further submitted that although the first appellate court in the impugned judgment has not framed any point of determination as such, but the same will not be decisive inasmuch as every aspect of the matter and every point has been considered by the learned first appellate court in the impugned judgment which has been passed after remand. The learned counsel has further submitted that all the materials have been taken into consideration to come to a finding that the learned trial court had wrongly decided issue number 4, and the learned first appellate court has held that Jamuna Devi was not the daughter of Chattu Ram. Chattu Jha. The learned counsel, while referring to Exhibit 9 by A, has submitted that the same is like a mutation order and it was arising out of sale deed, and this Exhibit 9 by A is not a document of inheritance, and therefore recording in Exhibit 9 by A that Shankar Jha was Nati of Chattu Jha has no value in the eyes of the court. इसका कोई डिस्कशन एपीलेट कोर्ट में नहीं है। 9A का कोई डिस्कशन एपीलेट कोर्ट में है सर? ना ये पूरा पर नहीं है ना। However, during the course of arguments, the learned counsel has fairly submitted that there is no discussion of Exhibit 9 by A in the impugned judgment passed by the learned first appellate court after remand.
मेरा हमारा सबमिशन को लिखवा दीजिएगा कि 9A is not a document of title.
The learned counsel has submitted that 9A, Exhibit 9A is not a document of title, and therefore it is irrelevant as to whether that document has been considered by the learned first appellate court or not. It has got not much relevance.
Because it was not supported by the mutation case and the registered document or what.
That's all. और कुछ बचा?
नहीं ठीक है. This is my ask. Judgment के बीच में हम नहीं बोलते.
Only few lines. The bachche may see the last paragraph of the impugned judgment, where the appellate court takes note of the fact, after 3 lines, that though the learned lower court has dismissed this suit, but while deciding issue number 4, the trial court has accepted that Yamuna Devi was the daughter of Chattu Jha, whereas this court has reached to a finding that Yamuna Devi was not the daughter of Chattu. Now, this finding of the trial court that Yamuna Devi was daughter of Chattu Jha, this finding was given by the trial court is not in dispute. But this was reversed. And how it was reversed, now your Lordship may see their submission which have been noted in in internal page 12, paragraph 11. First, our submission as appellant has been mentioned, and then para 11. The learned counsel, Sri so and so, appearing on behalf of defendant, respondent submitted that learned trial court has evaluated the evidences correctly and legally and has rightfully reached to a conclusion and passed the impugned judgment and decree in favor of the appellant. His praise for the impugned judgment be passed to so and so may be upheld and so. So my submission is that this finding was never challenged by them before the first appellant. And entire finding, including the ultimate judgment or decree passed by the trial court, that was supported by the appellant.
You were the appellant before the first appellant.
I was the appellant. So as respondent, they could have said that apart from this finding, we were challenging the conclusion of the court on this finding, but with regard to others, the court has rightly dismissed. But they
Not even
supported
at the initial stage also they did not challenge?
no.
At the later stage also they did not
Later
challenge?
stage also. So, Your Lordship, there is a judgment of Honorable Supreme Court where it says that where the parties have allowed at the interlocutory stage also have allowed a particular issue to become a final, then they cannot challenge it at a subsequent stage of the same procedure. So here, while discussing the provisions of 105, the Honorable Supreme Court has said, so in relation to this, my submission is that, Your Lordship, the moment the trial court said that apart from Jamuna Devi and Harka Devi, there was one third daughter, that and all three were daughters, this finding was absolutely remained final, and this finding was there by the trial court and it was affirmed by the appellate court in the first round. So when they filed an appeal, miscellaneous appeal, then they were required to have challenged this particular finding. They did not do so. So this finding was allowed to attain finality.
They could have even challenged it subsequently.
Subsequently also.
Even after the fresh order they could have challenged
Yes,
it because now a decree has come.
Yes.
Now a decree has come, they could have challenged that part of the order of the finding which attained finality at the stage of at initial first appeal. They could have challenged it even now, but they have not challenged it.
Yes. And now this is a peculiar situation that would come now. Now the first round the appellate court gives finding on approximately, let us assume, 8 issues. And can the court in second round take a contrary view to...
That's it. This is what we need to decide.
Absolutely cannot take.
This is what we need to decide.
So this judgment, Your Lordship, may kindly take.
Yes. The learned counsel for एक चीज और आपको respond करना पड़ेगा. The learned counsel for the appellant in response has submitted that the learned first appellate court in the subsequent judgment dated in the subsequent judgment after remand has recorded that though the learned lower court has dismissed the suit, but while deciding issue number 4, the trial court had accepted that Jamuna Devi was daughter of Chattu Devi, whereas the first appellate court reached to a finding that Jamuna Devi was not the daughter of Chattu. The learned counsel submits that the finding recorded with regard to issue number 4 was never challenged by the contesting defendant at any point of time.
And it is apparent from the submission made by them in para 11.
And he has also referred to the submission of the defendant. He recorded in paragraph 11, who had stated that the judgment passed by the learned court was required to be upheld. The learned counsel has submitted that in spite of recording finding that Jamuna Devi was daughter of Chattu Ram, the learned trial court at the initial stage did not allow partition. It was the plaintiff who had filed the appeal before the first appellate court, and the issue number 4 was, though not specifically challenged by the contesting defendant, but was considered by the learned first appellate court threadbare, and finding was recorded upholding the finding of issue number 4 by the learned trial.
Not upholding.
issue number 4 तो uphold किया था.
नहीं, issue number 4 को तो reverse कर रहे हैं.
नहीं, initial stage.
हाँ, initial stage. हाँ.
The learned counsel submits that the issue number 4, having attained finality at the first round, could not have been reopened by the impugned judgment. This is over and above the fact that issue number 4 was not even under challenge before the first appellate court at the time of passing the order after remand.
Yes, during argument at the final stage.
During argument at the final stage. ये शेयर के बारे में क्या बोलना?
Yes, share.
Because the learned
although the
miscellaneous appellate, the court said that आपको खाली अपना issue को remand करके भेजना. He has not argued it, but still, I have to put this question.
Absolutely, absolutely.
बोले हैं कि आप इसको issue को remand, आपको first appellate court में भेजना. और initially the court, by remanding the matter, has asked the trial court to partition also. So that part was modified in the miscellaneous appeal. The issues were to be decided and remanded and referred to the first appellate court for passing an appropriate judgment. So ये जो partition का जो share decide करना था, ये तो first appellate
This
court
would be ignored. This would be ignored altogether because it was over and above what was actually.
So what will be the consequence?
Yes, the consequence would be that this part your lordship would not see. What the consequence would be that now the trial court has given an answer on these two issues, that all the parties are there and all the properties are there. These two findings are there. Now the appellate court ultimately dismisses my partition suit. So my partition suit has to be allowed, and it has to be allowed the share he has rightly.
इसमें तो कोई डाउट ही नहीं है.
But
the genealogy etc. इसके बारे में क्या बोलना है?
Genealogy is not in dispute.
ठीक.
In my humble submission, genealogy is under dispute.
And they have said, your lordship, strangely,
they have modified the plaint to suit their purpose, and this would, my lord, negate the ends of justice. If a person or fair person was brought under the family for his look after, now he is harping upon the property.
merely because I have mentioned a wrong genealogy that she was not the daughter,
Yes.
would I be
As a
punished
whole
to such an extent
Partitions
that
would have, as my lords have just a few times back said, that only two things are required, not possession. Genealogy, that is relationship, and the jointness of the property, that is all. If genealogy was disturbing, he could have withdrawn the suit.
otherwise the trial court has actually rightly held that it was half and half and
Otherwise, if the genealogy, whatever was there, that there were 3 daughters
yes.
and 1 expired and 2 was there, then
Half
the
and half.
share is absolutely correct. There cannot be any doubt
Yes,
on that.
yes.
Provided it is held to be correct.
Yes,
If this is held to be correct, then there is no dispute that so far as distribution is concerned, there is no problem. But according to you, this genealogy was not proved.
It was not so.
Not proved, and they took a shifting stand.
Yes.
And the last submission that according to their own stand, Chattu had 3 daughters. They themselves say
तो बच्ची देवी
only
थी ना,
name is different.
तो उससे क्या?
So this
And बच्ची
submission,
died
Just-
in her childhood.
Just a moment.
She died in childhood. Harka died issueless. Only Jagta
The
remained.
learned counsel for the appellant has also submitted that if the fact that Chattu Devi had 3 daughters and Jamna Devi and Jakti Devi were only the surviving daughters, then the share which has been allocated by the learned trial court after remand is in accordance with.
yes,
The learned counsel for the respondent has further responded to this submission and has submitted that the entire genealogy was in dispute and the plaintiff has been taking shifting stand and therefore it cannot be said, and therefore the learned trial, the first appellate court has rightly held that Jamuna Devi was not the daughter of Chattuja.
Mine.
He has submitted that it was a specific case of the defendant that Chattuja had 3 daughters,
Yes.
but Jamuna Devi was not.
No. Bachchi Devi,
Bachi Devi
Jagta Devi, and
Jagta Devi.
Harka Devi.
and
Harka Devi.
Harka.
So Bachchi Devi died in childhood. Harka Devi was issueless, and only Jagta Devi's offsprings are
And he has further submitted that both the sisters, namely Jagta Devi and
Jamuna Devi and
Jagta Devi
Ja-
and Harka Devi had expired, and therefore the entire property would devolve upon the
Jagta.
legal heirs of Jagta Devi.
जी बच्ची देवी died
अच्छा, बच्ची
Child-
देवी
died in childhood.
इसको लिखिए बच्ची देवी किसका किसका डेथ हुआ, बच्ची देवी एंड जगता देवी.
नहीं
Harka,
बच्ची देवी
Harka.
died in
Sorry.
childhood.
कभी भी मरी, इससे क्या लेना देना है. बच्ची देवी एंड हरका देवी
Had no issue.
have expired,
Yes.
and therefore the entire property would devolve upon the legal heirs and successors of
Jagta.
Jagta Devi,
जी
who were the contesting defendant second party.
7 to 12 लिख दीजिए.
7.
Okay, who were defendant number 7 to 12.
Mine.
अब आप बैठ जाइए और सुनिए जजमेंट. देखिए, after hearing the learned counsel for the parties, कल सारा रेलेवेंट पोर्शन हम इसमें लिखा दिए थे. कल डिक्टेशन में सारा रेलेवेंट पोर्शन आपका जजमेंट का जो भी था, रिमांड का, सब लिखा दिया. This court finds that it is not in dispute that the suit property stood recorded in the name of Chattu Jha. And there was serious dispute in connection with number of daughters of Chattu Jha and as to whether the number of daughter of Chattu Jha there was also a dispute as to whether there was no dispute that Chattu Jha had no son.
Can I take 5 to
Are
10
you good?
minutes?
आप जा सकते हो सर, आप भी जा सकते हैं सर if you want to.
अब ले
The learned The plaintiff and defendant number 1 to 6 were claiming through Jamna Devi, who was said to be one of the daughters of Chhattuja, and defendant number 7 to 12 were claiming through another daughter of Chhattuja, namely Jagta Devi. The plaintiff the learned trial court had framed as many as 9 issues and with respect to and including issue number 4 as to whether Chhattuja had only 2 daughters, namely Jamna Devi and Harka Devi, or he had another daughter, namely Jagta Devi. The plaintiff claimed there has been amendment in the pleading, and it appears that the plaintiff claimed that Jagta Devi was not the daughter of Chhattuja, and the contesting defendant claimed that Jamna Devi was not the daughter of Chhattuja. However, it was not in dispute that Chhattuja had one daughter, namely Harka Devi, who had died issues. The said issue was decided by the learned trial court by judgment dated 12th of November 2009. Taking into consideration both oral and documentary evidence, including Exhibit 9 and 9 by A, and the learned trial court came to a definite finding that as follows. Therefore, I find and hold that Chhattuja had not only 2 daughters, but he had another daughter, namely Jagta Devi. The said finding, when read with the issue number 4, reveals that the learned trial court held that Chattu Devi had 3 daughters, Jamna Devi, Harka Devi and Jagta Devi. The learned first appellate court, in the appeal filed by the plaintiff, being title appeal number 47 of 2009, by judgment dated 21/2/2011. Also recorded a specific finding with regard to issue number 4, and also taking into consideration Exhibit 9 and 9 by A, and observe that the recital of Exhibit 9 speaks that Shankar Jha is Nati of Chattu Jha, semicolon. The Exhibit 9/A also disclose that Shankar Jha is the Nati of Chattu Jha, and he is the legal heir to inherit. The argument of the contesting defendant that Exhibit 9 and 9 by A filed by the plaintiff is a mistake list and could not be relied upon was also rejected. And the learned first appellate court recorded a finding that the learned trial court had rightly held that the plaintiff, defendant first party and defendant second party and third party are legal heirs of late Shankar Jha, Rameshwar Chaudhary, Nand Kishore Chaudhary, respectively, who are Nati, daughter's son of late Chattu Jha. It is not in dispute that Shankar Jha is daughter of Jamna Devi, as he had claimed so in the plaint itself. This court finds that the issue number 4 this court also finds that the learned first appellate court, while deciding issue number 4, has given a clear finding as follows. This quote continues. From the oral testimony of witnesses adduced, it is clear that witnesses have disclosed that late Chattuja had 3 daughters, namely Jamuna Devi, Harka Devi, and Jagta Devi. The plaintiff, in support of their contention, have filed documents before the court. The findings of the learned first appellate court in the judgment dated 21/2011 has already been quoted. The learned first appellate court, after having upheld the finding of the learned trial court with regard to issue number 4, was of the view that 2 further issues were required to be decided by the learned trial court, and consequently the matter was remanded to the learned trial court to frame the issue, 2 issues as follows. A. What was the properties of late Chattuja which was required to be partitioned between the plaintiff, defendant, first party and second party. B. Whether all the heirs of late Chattuja has been made party in the present suit. The learned trial court also directed that the learned subject shall give finding on these issues and decide the suit for partition. The learned trial court the learned first appellate court did not ask the learned trial court to return the findings on the aforesaid 2 additional issues so framed for further decision by the learned first appellate court. However, the judgment passed by the learned first appellate court dated 11/2/2011 was challenged by the defendant in miscellaneous appeal number 508 of 2014. And an argument was advanced that was in miscellaneous appeal numbered as 508 of 2014, which was decided by order dated 2/2/2017. This court took note of the fact that much time had elapsed from the date of the order of remand, and the fresh order to be passed by the learned trial court pursuant to the order of remand was at advanced stage, and therefore the This court was also of the view that no doubt duty is cast on the first appellate court to frame point for determination for adjudication, but it is also settled principle that when the court applies its mind independently and on examination and appreciation of evidence on record, it records its satisfaction by arriving at finding on each issue, either agreeing or disagreeing with the finding on the issue framed by the trial court that amounts to compliance of Order 41, Rule 31 of CPC. This court in MA number 508 of 2014 was of the view that the findings on the two issues was to be returned to the first appellate court at the earliest, and the appeal was to be decided within 2 months thereafter. The learned trial court, by deciding the two issues, on which there was an order of remand, decided the same by order dated 6/4/2017 and refused to enter into the argument advanced by the contesting defendant, questioning that Jamna Devi was not the daughter of Chattu Jha and was of the view that the point both the courts, that is the trial court at the first instance and the first appellate court, have decided that Chattu Jha had 3 daughters, namely Jamna Devi, Harka Devi and Jagta Devi. And therefore, by deciding the 2 points on remand, the learned trial court had no jurisdiction to re-agitate or reapprise the issue. And thus, the learned trial court refused to enter into such issue. The learned trial court also recorded that no further evidence was led and ultimately held that all the years of late Chattu Jha were already made party in the suit. The learned trial court on remand, while deciding issue number 2, the additional issue number 2 as framed by the learned first appellate court, has also observed that no further evidence was led in connection with the point as to what properties of Chhattuja were required to be partitioned amongst the parties, and consequently found that there were only 3 schedules to the plaint, that is schedule A, A1 and A2. And considering the admitted fact that Harka Devi had already expired, divided the property half and half between the legal heirs and successors of Jamna Devi on one hand and Jagta Devi on other hand. The legal heirs and successors of Jagta Devi were being represented by defendant numbers 7 to 11, and of that of Jamna Devi were being represented by the plaintiff and defendant number 1 to 6, and accordingly distributed the share amongst the legal heirs and successors of Jamna Devi and Jagta Devi. So far as the distribution of share as done by the learned trial court, while the judgment, while the order dated 6th of April 2017 upon remand is concerned, it is not in dispute amongst both the parties during their course of argument before this court that in case this court holds that Chhattuja had 3 daughters, namely Jamna Devi, Harka Devi and Jagta Devi, then the distribution is in accordance with law. However, it has been agitated by the learned counsel for the respondent that the learned first appellate court has recorded a finding in the impugned judgment passed after remand that the learned trial court had wrongly decided that Jamna Devi was the daughter of, and it is their case that the entire property of Chhattuja would devolve upon legal heirs and Jagta and successors of Jagta Devi, that is defendant number 7. The learned, this court further finds that the learned first appellate court, while passing the fresh judgment, while passing the judgment after remand, after the 2 issues were decided by the learned trial court and returned to the first appellate court, has not framed any further point for determination but while passing the judgment has laid great emphasis on the pleadings and amendments made by the respective parties, and also considered some of the materials on record and was of the view that and had expressed surprise that the plaintiff had amended the plaint, and in the plaint they came up with a new fact that Chattu Jha had in fact two daughters, only two daughters, namely Jamna Devi and Harka Devi, and had completely excluded Jagta Devi. The learned court also recorded that this creates a serious doubt about which type of descendants the plaintiff and defendant number 126 are, as they have no knowledge whether Chattu Jha had three daughters or two daughters. And the plaintiff had taken a different stand in the amended plaint, which created a doubt about the genuineness of the contents of the plaint. The learned court also recorded that all the oral evidences made by several witnesses who were examined on behalf of the plaintiff and defendant were on record, and these evidence all speak about the fact that Jagta Devi was the daughter of Chattu Jha. The learned court, in the operative portion at paragraph 16, has recorded that the plaintiff has not been able to prove that he was a descendant of recorded tenant, and that though the learned court had dismissed the suit, but while deciding issue number 4, the trial court had accepted that Jamna Devi was the daughter of Chattu Jha, whereas the learned first appellate court, while the impugned judgment after remand, reached a conclusion that Jamna Devi was not the daughter of Chattu Jha, and modified the judgment and decree of the learned trial. This court finds that the learned trial court, while the judgment dated 12th of November 2009, had recorded a clear finding that Jamna Devi was the daughter of Chattu Jha, and that Chattu Jha had three daughters, namely Jamna Devi, Jagti Devi, and Harka Devi, and it was not in dispute that the plaintiff was the descendant through Jamna Devi. the learned first appellate court in the first round, while passing the judgment dated 21/2011, had also given concurrent finding by and has upheld the finding of the learned trial court with respect to issue number 4. This court also finds that the matter was remanded to the learned trial court on two limited issues, which certainly did not include the issue as to whether Jamna Devi was the daughter of Chattu Jha. Consequently, the learned trial court upon remand did not disturb this finding by citing reasons that the finding with regard to issue number 4, that there was no scope for the learned trial court to enter into the dispute regarding issue number 4. This court finds that the learned first appellate court passed the impugned judgment dated 25th of January 2018 after the two issues which were decided by the learned trial court upon remand, and instead of disturb the finding with regard to issue number 4, which had already attained finality. This court is of the view that certain issues were finally decided by the learned trial court in the first round while passing the judgment dated 21/2/2011, which included issue number 4. And the same was not disturbed by the learned first appellate by this court, even in miscellaneous appeal number 508 of 2014. And the 2 points which were remanded for consideration by the learned trial court had no relation with the issue number 4. And further, before the learned trial court, no further evidence was led. In the impugned judgment, there is no discussion with respect to any fresh material which could have come before the learned trial court and would have a bearing in connection with issue number 4. Still, the learned first appellate court has disturbed the finding with regard to issue number 4 which attained finality, primarily by referring to the different stand taken by the plaintiff by amending the plaint. This court is of the view that the issue number 4 and consequently the fact that Chattu Jha had 3 daughters, namely Jamna Devi, Harka and Jamna Devi, Harka Devi and Jagta Devi. And Harka Devi had expired, had attained finality, and therefore this court is of the considered view that there was no scope for the learned first appellate court by passing the impugned judgment dated 6th of April, impugned judgment dated 25th of January 2018 after the judgment with respect to two issues passed by learned trial court dated 6th of April 2017. In view of the aforesaid facts and circumstances, the substantial question of law as framed by order dated 25/3/2025, that is whether the first appellate court was right in reversing the finding of the learned trial court that Jamna Devi was daughter of Chattu Jha, is decided in favor of the appellant and against the contesting respondents. And it is held that the learned first appellate court, while passing the impugned judgment dated 25th of January 2018, has travelled beyond its jurisdiction to disturb the finding which was already recorded with regard to issue number 4 by the learned trial court and upheld by the learned first appellate court by passing the judgment dated 12th of November 2009. So far as the substantial question of law whether the judgment and decree passed by the first appellate court is perverse on account of non-consideration of Exhibit 9 by A is concerned, this court is of the considered view. It is not in dispute by the learned counsel for the parties that Exhibit 9 by A has not at all been considered by the learned first appellate court while passing the judgment dated 25th January 2018 upon remand. However, the learned trial court, while deciding issue number 4, as well as the learned first appellate court, while deciding issue number 4, have taken into consideration the Exhibit 9 by A along with other exhibits including Exhibit 9. Since the argument in connection with Exhibit 9 by A is closely related to the finding that in connection with whether Jamna Devi was daughter of Chattu Jha or not, this court is of the view that this court, having held that the finding with regard to issue number 4 had attained finality at the first round by the first appellate court by judgment dated 12th of November 2009. Nothing further is required to be answered. ये दोनों को एक साथ कर देते हैं, है ना? Accordingly, this question of law is also answered in favor of the appellant and against the respondent. So far as substantial question of law number 2, law with regard to the impugned judgment being against the mandate of provision of Order 41 Rule 31 CPC is concerned, this court finds that the learned first appellate court, while deciding the impugned judgment dated 25th of January 2018, after the two issues were decided and forwarded to the learned first appellate court, the first appellate court has travelled beyond the jurisdiction while entering into the dispute as to whether Jamna Devi was the daughter of Chattu Jha. Without going into the earlier judgment dated 12th of November 2009, and without discussing the findings which stood concluded while the earlier judgment dated 12th of November 2009 has in fact acted contrary to the provision of Order 41 Rule 31 CPC. Had the learned first appellate court considered the mandate of Order 41 Rule 31 CPC, the court would have confined only to the additional issues which were required to be considered over and above what was already concluded by the earlier judgment dated 12th November 2009. However, the learned first appellate court has taken note of the fact that the learned trial court was to forward the decision on the additional issues to the learned first appellate court and was not supposed to pass the order of partition. But during the course of arguments, it is not in dispute by the learned counsel for the parties that if Jamna Devi is ultimately held to be one of the daughters of Chattu Jha, then under such circumstances the distribution made by the learned trial court would be as per law. Accordingly, this court is not inclined to proceed any further so far as this aspect of the matter is concerned. The aforesaid substantial question of law is accordingly answered. So far as the first substantial, इसका क्या करना है? 6 and 7. It was already decided.
लेकिन if both of us were in possession, then the court could not have dismissed the partition. This is my suggestion.
Otherwise, possession से क्या मतलब?
No, ठीक है. But despite the plaintiff and defendant being found in possession, then also
This possession also stood concluded earlier.
absolutely in the first round itself.
So far as issue number 6 and 7 is concerned, the finding in connection with the said issue also included, also attained finality while passing the judgment dated 12th of November 2009. The learned first appellate court, by deciding issue number 6 and 7, has recorded a clear finding that Shankar Jha had not inherited entire estate of Chattu Jha, and the defendant number 7 to 12 have also not no absolute right, title, and possession over the suit property, and therefore these issues were decided partly in favor of the plaintiff and partly in favor of the pro forma defendant. Partly in favor of the plaintiff.
It says that it is clear that plaintiff as well as defendant first party and second party are in joint possession. This is the conclusion.
Where is it?
Just before issue number 1, 2 and 8 of the appellate. Page 16.
Page 16.
Concluding
Yes,
line
the
of
learned first appellate court had also given a clear finding that the defendant first party and plaintiffs are not the exclusive possession over the suit property. Rather, it belonged to defendant third party also. Joint possession can't.
वही last line, last 2 lines, 3 lines. It is clear that plaintiff as well as defendant first party and second party and third
Page number
party.
17.
Page issue number 1, 2 and 8 से ठीक पहले वो finding is with regard
Trial court का.
नहीं appellate
Appellate court का page number.
page number 16
Page number 16.
issue number 1, 2 and 8 का ठीक ऊपर 3 लाइन. That is conclusion of issue number 5.
Conclusion of issue.
If your lordship takes up issue number 5, 6 and 7.
But considering the materials, oral and documentary evidence. यही तो है.
नहीं
Issue number 8 के ऊपर. कल तो आप लिखाए थे मुझे.
नहीं वो issue number 1, 2 and 8 your lordship has got.
नहीं 1, 2 and 8 तो नहीं है. इसमें तो appellate court का judgment.
Appellate court का
अच्छा trial court का. Just a minute.
appellate court का एक बार page 15
Just
में
a minute. Just a minute. हाँ yes. 5, 6 and 7.
हाँ उसका conclusion is at page 16 just before issue number 1, 2 and 8 last 3 lines are.
Yes, yes. The learned first appellate court in the earlier round had recorded a clear finding that the property was in joint possession. The relevant portion has already been quoted above. Such finding had also attained finality, and in spite of such finding having attained finality, the learned first appellate court subsequently, while passing the improved judgment, was not justified in dismissing the suit. Considering the fact that, considering the aforesaid answer to the substantial question of law, the impugned judgment passed by the learned first appellate court cannot be sustained, which is hereby satisfied.
And then consequent order has to be there.
The office is directed to prepare a decree in connection with, is also directed to prepare a decree indicating the respective share of the parties.
It
As
would be better that your lordship dictates that.
तो उसका जो finding है,
हाँ,
जो ट्रायल कोर्ट का जो finding है upon
the
remand, वो
suit
जो
of the
share
plaintiff is decreed.
in this term.
हाँ, in these terms. वो
The suit of the
specific है.
plaintiff is decreed in the following terms. वो जो share
वही,
divide
हाँ,
किए
हाँ,
हैं वो
exact, वही,
ठीक.
it has. But unless there is a decree
That's
by
right.
your lordship, it would not.
we'll do that. उसमें तो कोई dispute नहीं
नहीं
है.
नहीं उसमें नहीं.
Allowed in appropriate terms. Judgment आने में time लगेगा ना. Just have patience.
नहीं.
आप अप्लाई कर दीजिए सर्टिफाइड कॉपी. सर अप्लाई कर देंगे आप लोग भी सर्टिफाइड कॉपी, जिससे कि वो एक्सक्लूड हो जाएगा पीरियड. आई विल टेक टाइम टू करेक्ट.
DT list for final disposal fifth case item 5, second appeal 127 of 2019.
Respondents. The arguments were complete on last two.
Arguments were completed, yes. इतना अभी नहीं लिखा पाएंगे, इसको सीएवी कर लीजिए। बाकी आर्गुमेंट सब अपलोडेड है, सब रिकॉर्डेड है, इसमें इसको जो है ना, यस क्या नाम है, एक्सक्यूज मी, आप रंजीत जी 4:30 बजे आइएगा डिक्टेशन में, इसको लिखाएंगे। इसका जो प्रीवियस एडजमेंट ऑर्डर है सब लेंगे। हाँ ये भी कर दीजिए, इतना नहीं लिखा। एक सुनना भी है कल का।
From supplementary list for hearing item 17, second appeal 34 of 2023. Against activity.
Yesterday our argument was complete.
आप straight away you complete your argument.
The second appeal at serial number 18 has been admitted. On the following,
ऐसे नंबर बताएंगे।
essay number 43,
43,
49, 49,
49 हाँ
49. Paragraph 8 of essay number 34 का ऑर्डर जो था, ऑर्डर नंबर 11/5/2025,
हाँ बताइए।
whether the learned court, lower appellate court, erred in discarding the judgment of the learned trial court in terms of returning of consideration amount of rupees 2,50,000 to the appellant as same amount to unjust enrichment to plaintiff. On this issue, the first appeal was admitted, second appeal was admitted, second appeal 49. Thereafter, this appeal has been admitted for the reason that one appeal has already been admitted, therefore subsequent second appeal has been also admitted by the Lordship. In this matter, Lordship, Anita Devi, the defendant herself has been examined, wherein certain questions were put to her.
PW
DW3.
नहीं एविडेंस दिखाइए।
DW4, Anita Devi DW4. Paragraph 18 for cross-examination. May I permit to place it? Paragraph 18, cross-examination of Anita Devi.
Para 18.
जमीन खरीद बिक्री की बातचीत वादी के साथ वादी के घर पर हुई थी। वादी के साथ बातचीत हुई, कब हुई ये नहीं तिथि नहीं बता सकती हूँ। जमीन खरीद बिक्री के बातचीत के समय कोई खाता नहीं बना था। जमीन खरीदने के लिए डीसी सरायकेला से अनुमति प्राप्त किए थे। दिस इज इम्पोर्टेंट। जमीन खरीद के लिए डीसी सरायकेला से अनुमति प्राप्त किए थे। साक्षी पुनः कहती है इस समय डीसी का
आदेश की जरूरत नहीं।
Thereafter, she has said. Therefore, this question has arisen subsequently.
पुनः कहती है कि उस समय but it was not required.
लेकिन permission was already there. She has admitted permission was not there. A permission was there, but subsequently she has justified her statement.
That permission was not required.
Permission was not required.
ये तो परमिशन की बात कर रहे हैं।
परमिशन
आप
in
तो ये
46 in section 46.
आप एक इशू से दूसरे इशू में मत जाइए। आप जब ये ऐसे 49 वाले जो इशू पर आप बहस कर रहे हैं तो इस पर आप फोकस करेंगे। इसको इसका आर्गुमेंट को
इसका आर्गुमेंट मेरा सबमिशन ये है कि the appellant was aggrieved by non-refund of money. Therefore, he has preferred SA 49.
ऑल्टरनेटिव है ना, दोनों चीज नहीं चला जाएगा, जमीन भी चला जाएगा और पैसा भी चला जाएगा। इनका ये कहना इन्होंने कल ही आर्गुमेंट में बोला है अगर दूसरा अपील इनके फेवर में डिसाइड होता है तो ये रिडंडेंट है उनके लिए। He will not press this. If the main issues are decided in his favor, this is absolutely irrelevant.
Therefore, the first appellate court has also considered this issue.
Yes.
Judgment of first appellate court. Thereafter, I will place the Dian.
इशू नंबर 7 पर ही होगा ना ये वाला इशू का
Issue
फाइनल
number 6 पर था।
7
हाँ 7 पर तो 46 का
रिफंड वाला नहीं 7 पेज 44 है इंटरनल पेज 20
I am placing page 13 of first appellate court judgment.
रिफंड का इशू कौन सा इशू से कवर है?
रिफंड का इशू तो इशू नंबर 7 से कंसिडर 7 से
उसको कंप्लीट कर लीजिए ना।
हाँ।
फर्स्ट एपेलेट कोर्ट का फाइंडिंग है इशू नंबर 7 पर, तो उसको पढ़ लीजिए।
Page 21. So I find that
20. But while deciding issue number 6.
But while deciding issue number 6, learned trial court also directed the plaintiff to return consideration amount to the defendant. No relief has been sought for regarding the consideration amount of sale deed number so and so. No parties claim to set consideration amount and no such issue has been framed. The admitted fact in regard to the alleged sale deed is that same was prepared for sale of land belonging to plaintiff. It is a case of plaintiff that defendant cheated the plaintiff and during intoxicated state of plaintiff defendant obtained his thumb impression on sale deed. He neither sold his land nor taken consideration amount, whereas defendant pleaded that plaintiff in sound mind executed sale deed to him and received the consideration amount. Perused the oral and documentary evidence of both sides, plaintiff PW4 stated in para 19 that he earlier given money to Lok Mahato for land which he purchased, and it is wrong to say that for said payment he sold his land, and he not sold land. During his cross-examination in denial, he stated that it is not true that on getting consideration amount from the dependent, he purchased other land. Both the plaintiff and defendant are from backward class of state district, same district, and as per section 46 of CNT Act, without obtaining permission from Deputy Commissioner, person of said class cannot transfer the land. Plaintiff himself denied about the execution of said deed in para 35 of cross-examination and make charge upon the defendant that he has been cheated it is mentioned in para 4 of the statement of PW4. Antu Sundi. Antu Sundi is the person who has prepared the sale deed. On affidavit that on 26/6/2006 plaintiff was intoxicated and not able to move, and on request of Birbal Mahato and Ganga Sahu, he put thumb impression on deed. So I find that said part of direction given by the trial court is while deciding issue number 6 that
So
plaintiff
according to the first appellate court, since it was absolutely fraudulent, there was no consideration, so there could not have been any order of
loss.
But the learned appellate court also recorded that the amount was already paid.
That has been recorded.
That has been. Para 19 of PW4, right? Where is PW4? You read PW4. Para 19.
मैं देवेंद्र महतो, देवेंद्र नाथ महतो, so and so.
नहीं पैरा सीधा है ना, पैरा 19 में है.
पर 9 इम्पोर्टेंट है, इसको भी प्लेस कर दीजिए.
एक इशू को खत्म कर दिया है, इशू वाइज प्लेस.
पैरा 17 से प्लेस करते हैं इसको. यह कि मेरे द्वारा खरीद किया गया जमीन का इकरारनामा जो सेकंड से था एग्जिबिट 1/A उसके लिए कहते हैं. मेरा
पैरा 17.
हाँ पैरा 17. यह कि मेरे द्वारा खरीद किया गया जमीन का इकरारनामा जिस विक्रेता एवं गवाहों का हस्ताक्षर दिनांक 5/6/1984 को सरायकेला में बना था. मेरा प्रायर डीड था, शेरपुरदीन रजिस्टर हुआ था. यह कि उपरोक्त मेरे द्वारा खरीद किया गया जमीन के इकरारनामा पर विक्रेता त्रिलोक महतो, क्रेता स्वयं एवं गवाह सहदेव महतो, रंजीत महतो, महादेव महतो और रमेश चंद्र महतो का हस्ताक्षर जिसे मैं पहचानता हूँ. यह कि उपरोक्त पैरा 19 सेल डीड नंबर 1641 जो हमारे फेवर में हुआ था एग्जीक्यूट, उसके लिए ये पैरा 17 था. सेल डीड नंबर 1640 is under challenge.
ये जो 5/6 की बात कर रहे हैं ना, 5/6/84.
हाँ 5/6/84 that was the sale deed.
That is not a sale deed, that is an agreement.
Agreement prepared in my name, which has subsequently converted into sale deed on same
agreement
day.
में क्या लिखा है?
उस एग्रीमेंट में ये था कि वो हम लोग जमीन खरीदेंगे, उसके लिए बाद में सेल डीड हुआ 1641.
पैसा उसी समय दे दिया
हाँ
था सारा.
नहीं पैसा तो एट द टाइम ऑफ एग्जीक्यूशन दिया गया, ये आया एविडेंस में.
एट द टाइम ऑफ एग्जीक्यूशन दिया गया
एट द
ना।
टाइम ऑफ
तो ये जो ये बोल रहे हैं कि पैरा 19 में मैं पहले ही दे चुका था, ये कहाँ से बोल रहे हैं?
पार्ट कंसिडरेशन होगा, लेकिन हम ये भी आया है
नहीं
कि
नहीं, मैं ये जो
हाँ।
बोल रहे हैं ये मैं त्रिलोक महतो को जमीन पैसा पहले ही दे चुका था, ये कहाँ से बोल रहे हैं? वो जो एग्रीमेंट है ना उसमें पार्ट पेमेंट की बात है, और उसमें लिखा हुआ है कि जब रजिस्ट्री होगा उस समय पेमेंट करना।
हाँ, तो रजिस्ट्री होगा तो
पहले
उसी
ही
दिन
दे चुका था मतलब
पार्ट पेमेंट हुआ होगा, एग्रीमेंट को नहीं देखते एग्रीमेंट।
हम देखे हैं ना, इसीलिए पूछ रहे हैं। जो चीज आपके खिलाफ है उसको मत देखिए, आधा
नहीं
चीज
नहीं, पूरा ही देखना है।
इसीलिए बता रहे हैं,
हाँ।
हम देखे हैं तो बता रहे हैं।
हाँ, ठीक है। फर्स्ट अपीलेट कोर्ट में कभी भी लर्नर फ्रेंड का ये स्टेटमेंट नहीं था कि हम लोग कुर्मी महतो नहीं है, इसलिए वो
आप दूसरा चीज में मत
हाँ
शिफ्ट
नहीं, ठीक है, अभी कंसिडरेशन पर ही रहते हैं,
कंसिडरेशन।
कंसिडरेशन पर ही रहते हैं। पैरा 99 प्लेसिंग यह कि उपरोक्त इकरारनामा वाला जमीन का खाता नंबर 100 प्लॉट नंबर इतना छोटा गमैया पर स्थित है और लोक महतो को जमीन का पैसा पहले ही दे चुका हूँ। प्रतिवादी का यह कहना गलत है कि मैंने उपरोक्त इकरारनामा वाला जमीन का मूल्य चुकाने हेतु विवादित संपत्ति को प्रतिवादी को बेच दिया। मेरे द्वारा कोई जमीन नहीं बेचा गया और न ही जमीन बेचने की कोई आवश्यकता थी, क्योंकि मैं टाटा कंपनी में कार्यरत था और वर्तमान में अवकाश ग्रहण कर चुका हूँ। और पीडब्ल्यू के एविडेंस में जहाँ भी मतलब प्रोसिक्यूशन प्लेंटिफ विटनेस जो भी एग्जामिन हुए, सब लोगों ने कहा कि हाँ ये फिट स्टेट ऑफ माइंड में कभी नहीं रहते थे, क्योंकि ऑलवेज ही इज इन ड्रंकन कंडीशन। ये सब विटनेसेस का आया है। इनकी वाइफ का भी PW6 जो है, ये वाइफ है और मौसी है
तो खरीदने के लिए
DW4 की।
बेचने के लिए ठीक स्टेट,
बेचने के लिए फिट स्टेट ऑफ माइंड होना चाहिए, खरीदने के लिए
खरीदने के लिए नहीं होना चाहिए।
खरीदने के लिए नहीं भी हो सकते हैं, तब भी सेल डीड एग्जीक्यूट होगा, क्योंकि वो जो पर्सन है सब्सक्राइबर है सेल डीड का, ही हैज टू prepare the sale deed on his instruction, prepare sale deed is required to be prepared.
तो जो सेल डीड में जो साइन करते हैं ये लोग,
हाँ।
इन्होंने अपने रिटन स्टेटमेंट में लिए हैं कि हम तो पढ़े लिखे हैं, हम तो साइन करते हैं, अंगूठा नहीं लगा।
हाँ, अंगूठा नहीं लगाते
तो
हैं।
दूसरा सेल डीड में
दूसरा
अंगूठा क्यों
सेल
लगा?
डीड में अंगूठा लगा।
क्यों? ये सब स्टेटमेंट गलत नहीं है क्या? यस।
ये तो एक्चुअली नेगेटिव हम लोग के अगेंस्ट।
हाँ तो
हाँ।
चीज है ना आपके अगेंस्ट में।
लेकिन
यू सी बोले हैं कि सुबह से ही हमको पिलाई हुए
हाँ, तो सुबह से ही सुबह से ही पिए हुए थे ड्रंक, और सारे लोग विटनेसेस भी बोले हैं कि हाँ वो हमेशा पीते रहते थे, वो सालों भर पीते ही रहते थे।
जो आदमी
ऐसा ही
सालों भर पीते हैं वो हमेशा होश में रहते हैं, ये भी तो सच है, वो हमेशा बेहोश नहीं रहते हैं।
मैं उस दिन कुछ ज्यादा पिया, मात्रा जो कंट्री में लिकर है उसका मात्रा पर निर्भर करता है।
फॉरेन लिकर लिखा है, कंट्री मेड लिकर।
कंट्री मेड एंड फॉरेन लिकर दोनों उसमें आया है, प्लेंट में शुरू में ही आया है।
इंटॉक्सिकेशन का कहानी आपका बनता नहीं है। आपका जो ये प्ली है कि हम तो साइन करते हैं, हमसे अंगूठा लगवा लिया जबरदस्ती, ठीक
ले
है,
जाकर के, क्योंकि for the
वो आप
reason
नहीं
that
ले सकते क्योंकि
hardly
दूसरा में तो आप
6 kilometers away from the
नहीं, और
residence
जो विटनेस है, जो राइटर है, डीड
हाँ,
राइटर
हाँ,
है ना,
हाँ,
ही इज आल्सो द डीड राइटर ऑफ द अदर डीड।
हाँ,
बोले हैं कि इन्हीं के इंस्ट्रक्शन पे उसी दिन हम लिखे हैं,
आप बोले हैं, लेकिन वही
इनके
बोले हैं
इंस्ट्रक्शन पे उसी दिन लिखे हैं।
लीड राइटर ये भी बोला है कि हाँ ये ड्रंकन कंडीशन में हमारे पास आए थे, क्रॉस एग्जामिनेशन में सपोर्ट नहीं किया।
क्रॉस एग्जामिनेशन में सपोर्ट नहीं
हाँ,
किया, बोले खुद चल के आए,
क्रॉस एग्जामिनेशन में वो ये कहा कि
खुद चल के आए थे।
जो डॉक्यूमेंट हम बोले हैं, क्योंकि वो डिक्लेरेशन दिया था खुद सेल राइटर की ऑन इंस्ट्रक्शन, तो उससे वो डिफर नहीं कर सकता था, इसलिए प्रीवियसली तो एफिडेविट में बोला कि ही वाज इन ड्रंकन कंडीशन एंड ही वाज ब्रॉट बिफोर रजिस्ट्री ऑफिस इन ड्रंकन कंडीशन। ये इसके हस्बैंड लेकर के आए, डिफेंडेंट के हस्बैंड लेकर के आए, उसके साथ दूसरा विटनेस भी था, लेकिन जब क्रॉस एग्जामिनेशन हुआ उस समय वो
इस चीज को कंसीडर किया है कोर्ट, बिकॉज वन ऑफ द क्वेश्चंस ऑफ लॉ इज कंसीडरेशन का तो हो गया, बात खत्म।
हाँ।
एग्रीमेंट में लिखा है कि रजिस्ट्री के समय कंसीडर पैसा दे,
एग्रीमेंट मेरे वाले केस में
आपके वाले केस
हाँ,
में रजिस्ट्री के समय पैसा दे।
1641 जो सेल रीड है
यस 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 ऑफ कोर्स। तो उस दिन तो पैसा का ट्रांजैक्शन कोर्ट में हुआ है,
हाँ,
ठीक है।
हाँ।
तो इन्होंने उस दिन पैसा दिया है और जमीन खरीदा है। कोर्ट बोलता है कि इस डीड को चैलेंज नहीं किया, कौन परचेजर अपना डीड को चैलेंज करेगा?
कौन परचेजर अपने डीड को चैलेंज करेगा?
तो ये
दैट इशू
इसको हम क्या समझें? that issue is not before the court and it will never be before the court because the purchaser of the property will not challenge his own deed कि हम drunken state में थे, हमको जबरदस्ती बेच दिया।
हाँ, लेकिन ये
होगा
कंसिडरेशन
क्या?
नहीं, कभी नहीं होगा।
ये कंसिडरेशन है ना,
ये कंसिडरेशन ये जस्टिफाई करने के लिए है कि
किसी भी चीज को जस्टिफाई करने के लिए
1640 was before under challenge before trial court.
but the court has completely not taken into consideration कि एक आदमी एक ही दिन में उसी पर बोल रहा सुबह से पिए हुए, ऐसा नहीं है कि बाद में पिला दिया और ले आया, सुबह से पिए हुए थे, उसी दिन आकर he is giving वो बोल रहा है कि उसी दिन डीड बना है, सेम डे।
ये अब तो मतलब जो एविडेंस में है वो एक सिचुएशन है, लेकिन
इसीलिए
एक
ये जो
सिचुएशन ये हो सकता था जो एविडेंस नहीं भी आया, ये सिचुएशन हो सकता था कि इसी सेल डील को 1641 को सेल डील को मेरे फेवर में एग्जीक्यूट कराने के लिए लोग साथ गए, क्योंकि मेरे बेटी दामाद ही थे, मेरी वाइफ के बेटी दामाद थे, मतलब वाइफ की
ऐसा
बहन
तो कहानी नहीं बनाया ना,
नहीं कहानी नहीं बना, लेकिन हुआ यही हुआ
कैसे हुआ
नहीं
ये जो बोल रहे हैं कि अंगूठा
1641
कितना फेलेसी है इनके रिटन स्टेटमेंट में, बोलते हैं कि हम सिर्फ साइन करते हैं प्लेंट
हम प्लेंटिव,
हाँ सिर्फ हम साइन करते हैं, हम तो अंगूठा कभी नहीं
लेकिन इनका
लगाते, और अपना ही डीड में
डब्ल्यूएस देखा जाए, डिनायल
डब्ल्यूएस में क्या देखें?
डब्ल्यूएस में इसलिए कि मेरे जो ये एलिगेशन है पारा 10, 11, 12 का, इसका रिप्लाई क्या देते हैं?
क्या देते हैं?
भाई प्लेस कर सकते हैं।
You see, on the same day he is executing 2 deeds.
Yes.
एक के लिए ड्रंकन है, दूसरे के लिए नहीं है।
हाँ, तो दूसरा तो चैलेंज नहीं हुआ ना, जो
चैलेंज कौन करेगा?
जो एग्जीक्यूटेंट है, जो सब्सक्राइबर और
एग्जीक्यूटिव क्या चैलेंज करेगा?
अगर उसको
खरीदने वाला ड्रंकन स्टेट में था
कि नहीं हम पैसा नहीं दिए या ड्रंकन कंडीशन में रहते, तो वो
परचेजर कैसे चैलेंज करेगा, और जो बेचा है वो उसको पैसा मिल
गया
गया,
वो क्यों चैलेंज करेगा? उसको मेरे अगेंस्ट कोई ग्रीवांस नहीं है। हां, इसलिए 1641 वाज नॉट चैलेंज,
naturally it will not be challenged.
हां,
but his statement that he never puts his thumb impression is falsified on the face of it. झूठा आदमी का क्या हम लोग करें बताइए?
लेकिन डब्ल्यूएस में देख लिया जाता है कि क्या
डब्ल्यूएस से ये झूठ बोल रहा है कि नहीं सच बोल रहा है?
नहीं, ये दो पॉइंट पर डब्ल्यूएस मेरे सबमिशन के मुताबिक 2 पॉइंट पर डब्ल्यूएस गलत है। एक पॉइंट पर ये कि ये लॉजिक ये ले रहे हैं कि अगर हम कंसिडरेशन अमाउंट नहीं दिए हैं तो आप लीगल नोटिस भेजिए और उसके बाद रिकवरी ऑफ मनी के लिए सूट फाइल कीजिए। ये डब्ल्यूएस में आया एक जगह। दूसरा ये आया कि हम ड्रंकन कंडीशन में थे, हमको जबरदस्ती ले जा करके इनके हस्बैंड और उसके साथ वाले आदमी वहाँ एग्जीक्यूट कराए सैलरी। इसका इन्होंने स्पेसिफिक डिनायल नहीं किया, इसका इवेसिव डिनायल हुआ है डब्ल्यूएस में।
आप अगर ये बोल रहे हैं कि आपके साथ फ्रॉड हुआ है, आप ड्रंकन स्टेट में थे, आपको उठा के ले गए, प्रूफ किसको करना?
हमको करना था।
हाँ, तो डब्ल्यूएस से क्या सपोर्ट मिल जाएगा?
आप
ही का तो गवाह बोल रहा है कि नहीं वो खुद ही चल के आए थे, कहाँ सपोर्ट किया है?
क्रॉस में तो टूट गया,
क्रॉस में तो बोला है ना खुद ही चल के आए थे।
क्रॉस में तो मेरा बात सपोर्ट नहीं किया, जो एफिडेविट पर लिखा उसके अगेंस्ट
क्रॉस में तो गवाह आपको सपोर्ट ही नहीं किया।
और मेरा एक और सबमिशन है कि अपीलेट कोर्ट में जो इन्होंने अपील का फाइल किया फर्स्ट अपील में, उसमें अब 46 पर आ जाते हैं। सेक्शन 46 का जो कास्ट का इशू था कि वेदर द प्लेंटिफ एंड डिफेंडेंट्स आर कुर्मी बाय कास्ट महतो, they are using title that has never been denied in entire appeal, memo of appeal. I have also examined the memo of appeal. In memo of appeal, my learned friend first appellate court in appeal before first appellate court, they have not made single statement that this is not correct position. They are not belonging, or even defendant is not belonging from Kurmi community. अगर वो इशू एक फ्रेम हुआ फर्स्ट अपीलेट कोर्ट ने इशू एक फ्रेम किया, तो दैट हैज नॉट प्रॉपर्ली बीन आंसर्ड, लेकिन इशू फ्रेम करके उनको भेज देना चाहिए था। इशू फ्रेम किए जजमेंट में, वही पैरा 13 में हम दिखाना चाह रहे हैं, पेज 13 फर्स्ट अपीलेट कोर्ट का जजमेंट।
पेज नंबर
पेज नंबर 11 था, पेज 20 नहीं, पेज 11, पेज 13, पेज 13, paragraph 13. On perusal of oral and documentary evidence as well as judgment, I find that issue number 4 decided in favor of plaintiff against the defendant, wherein the trial court pleased to mention that said deed is barred by section 46 of CLT Act, as both the party related backward class and no previous sanction of deputy commissioner has been obtained for execution of said deed number so and so. Therein it is mentioned that P.W.4 plaintiff in para 34 admitted that he along with witness went to the registry office, and in para 35 he admits that he executed said deed number so and so in favor of Anita Mahato, and on same day he purchased the land from Trilok Mahato and paid consideration amount, but he denied about the receiving the consideration amount from the defendant. इससे पहले एक और जगह प्लेस करना था, पेज 9, पेज 9, उसी जजमेंट का पेज 9।
just a moment.
पेज 9 का सबसे लास्ट पैराग्राफ।
फर्स्ट अपील में एपिलेंट कौन?
फर्स्ट अपील में 2 अपील हुआ ना।
2 अपील है ना?
हाँ, एक अपील हुआ मेरे तरफ से, जिसमें हमको कंसिडरेशन अमाउंट रिटर्न करने के लिए एक्शन हुआ था, दैट हैज बीन चैलेंज बाय प्रेजेंट डिपेंडेंट। ये
आपका नाम क्या है?
देवन महतो।
देव।
देवेंद्र नाथ महतो। आई एम द प्लेंटिफ।
यस। और दूसरा मेमो ऑफ अपील लिखा है?
दूसरा, हाँ, 2 मेमो ऑफ अपील।
दूसरा मेमो ऑफ अपील लिखा है? सारा ग्राउंड है?
पेज 9 का, वही फर्स्ट अपीलेट कोर्ट का जजमेंट का पेज 9 का लास्ट पैराग्राफ प्लेस करना चाह रहे हैं। That the learned court should have relied upon the oral and documentary evidence adduced on behalf of appellant plaintiff, and he should have decided the issue number 7 as plaintiff brought the suit for cancellation of said deed number so and so and confirmation of possession over the scheduled land of the plaintiff as said deed was executed
Sorry,
without.
just a moment. You are at internal page 9
Internal page 9 of first appellate court judgment.
of first appellate court judgment. Yes. Para 10
Para 10 का, हाँ,
Roman.
हाँ, Roman 4,
Roman.
Roman 4,
अब
इसको दोबारा
हाँ,
please
प्लीज
करो।
दोबारा।
That the learned court should have relied upon the oral and documentary evidence adduced on behalf of appellant plaintiff and should have decided the issue number 7 as plaintiff brought the suit for cancellation of said deed number so and so dated so and confirmation of possession over the scheduled land of plaintiff as sale deed, ये important है, as sale deed was executed without consideration and without permission from the deputy commissioner Saraikela Kharsama. This issue was raised before the appellate court also. The appellate court has to frame this issue and answer accordingly or refer the matter before the trial court for reappreciation of and deciding this issue.
Can any issue be framed beyond the pleadings?
Obviously, it must be pleaded in appeal.
Pleading, अपील में कैसे pleading होता है? अपील में pleading होता है plain written statement amend
हाँ।
करके। जब तक plain written statement नहीं amend होगा, कौन सा pleading हो जाएगा?
यही तो मेरा
Memo of appeal से कोई pleading नहीं होता।
यही तो मेरा भी सबमिशन है कि अपीलेट कोर्ट ने यहाँ इशू कंसीडर किया, इशू हैज नॉट बीन फ्रेम्ड। वो 41 ऑर्डर 41 रूल 29 का पावर इन्वोक करते हुए कर सकते थे
अगर फाउंडेशनल प्लीडिंग हो। बिना फाउंडेशनल प्लीडिंग के, इनका यही कहना है, बिना फाउंडेशनल प्लीडिंग के ना तो इशू फ्रेम हो सकता है ना डिसाइड हो सकता है।
ये
ट्रायल कोर्ट ने इशू फ्रेम ही नहीं किया, डिसाइड कर दिया, एपेलेट कोर्ट ने उस इशू को अफर्म कर दिया।
अपीलेट, यही मेरा सबमिशन है यहाँ इस पॉइंट पर एट दिस जंक्चर कि अपीलेट कोर्ट ने ये इशू एक फ्रेम किया यहाँ आकर के, क्योंकि ये तो अगर प्लीडिंग ऑफ द पार्टीज नहीं भी था तब भी इन्होंने फ्रेम किया। ये फ्रॉम
गलत न किया, यही इनका यही आर्गुमेंट है। When the parties do not join issue on one or the other point, then under such circumstances, how such a issue can be framed or even decided?
डिसाइड तो नहीं हुआ ना। This issue has not been decided by the first appellate court. Rather, it was discussed.
The issue regarding section 46
सेक्शन 46 के लिए और
डिसाइड किया ना,
डिसाइड किया। हाँ, डिसाइड वो तो ट्रायल कोर्ट का ऑलरेडी इशू नंबर 7 था, उसी को डिसाइड करते
इशू नंबर 7 में तो 46 का इशू नहीं बना।
फर्स्ट अपीलेट कोर्ट ने तो यही
ट्रायल कोर्ट
consider
ने तो नहीं किया है इशू नंबर 7। इशू नंबर 7 is not relating to 46।
एनी अदर रिलीफ्स में किया, एनी अदर रिलीफ्स में
एनी अदर रिलीफ में,
हाँ,
देखिए
उसी
आपको
में-
आपको
उसी
सरल भाषा में समझाते हैं। एनी अदर रिलीफ में 302 का पेशेंट को क्या, नहीं सॉरी 304 के एक्यूज्ड को हम लोग 302 में कन्विक्शन कर देंगे। एनी अदर रिलीफ में होगा,
अल्टरेशन ऑफ चार्ज होगा तभी होगा।
तभी ना होगा,
हाँ,
तो अमेंडमेंट ऑफ प्लीडिंग होगा तभी होगा।
हाँ, अमेंडमेंट ऑफ प्लीडिंग होगा तभी होगा।
बात खत्म। वैसा ऐसा भाषा आपको समझ में आता है।
नहीं, इसमें इशू
चलिए
यही था
second
कि
second
अपीलेट
आगे